Hello students, welcome to EPG Pathshala. I am Dr. Arun Singh Thakur, Assistant Professor, University Institute of Hotel and Tourism Management from Punjab University, Chandigarh. Today, we are going to discuss about the module Companies Act 2013 from the paper Tourism and Hospitality, Entrepreneurship and Legal Environment. The module will facilitate you to understand the meaning, nature, kinds of companies, company formation, concept of corporate personality, meaning of incorporation, concepts involved in company law. So, let us start. The Companies Act of 2013 is a modified version of the Companies Act 1956. It is the recent law which was found, the earlier law was found outdated and needed substantial revamp because of the significant changes in the corporate sector. Therefore, the Parliament repealed the earlier Act of 1956 and passed the present Act of Companies Act 2013 on August 29, 2013. The Act is one of the largest enactments so far passed by the Indian legislature and consists of 470 sections, 29 chapters and 7 schedules. Now let us discuss about the Indian Contract Act, an act to consolidate and amend the law relating to the companies and certain other associations. This is the basic law which governs the creation, constitution, the winding up of companies and also the relationship between the shareholders, the company, the public and the government, coupled with other statutes dealing with corporate entitles. This is an extremely important piece of legislation. Definition of a company. Company having no legal or technical meaning. Companies Act defines it as a company formed and registered under the Companies Act. As per the common law, a company is a legal person or legal entity and capable of surviving beyond the lives of its members. Let us understand meaning of a company. The word company has no technical legal meaning. It is described as an association of persons for some common objective. The purpose for which people may associate themselves are diverse and include economic as well as non-economic objectives. But in common parlance, the word company is normally reserved for those associated for economic purpose, that is, to carry on the business for profit. Company can be defined as a company is an artificial person created by law having separate entity with a perpetual succession and a common seal. This definition was given by Professor Hene. Now we'll try to understand the meaning of company. The word company is used in two legal senses. One, the constituent individuals of association incorporated according to the law. The Act defines company as a company created and registered under this Act or existing company. An existing company means company created and registered under the Act of previous company laws like the Companies Law of 1956. Corporation or a body corporate. In general terms, the body corporate connotes an organization of two or more people integrated as per the suitable regulation and dressed with legal character served as of individuals comprising it. A company includes within a commercial aggregate implying a group of many personnel combined in one organization under a special denomination having a continuous chain under a non-natural form conferred by law. Now we'll describe the various essential features of a company. And the important ones are the registration, which is compulsory. Company is a separate legal entity. It is a distinct person. It is having a perpetual succession. It is artificial person but cannot be called as a citizen. It's having transferable shares. Company is having limited liability. There is a common seal of the company having separate and independent legal existence. There is separate property of the company. It can dispose property in its name. There is capacity to sue and be sued. Now we discuss the various modes of incorporation of the company. In India, a company may be built in either by a special statute or by registration under the Companies at current point of time. On the basis of the mode of corporation, the companies are named as 1. Statutory company or corporation like the Reserve Bank of India, recognized under the Reserve Bank of India Act 1934, the Industrial Finance Corporation of India under the Industrial Finance Corporation Act 1948, the Air India under the Air Corporation Act 1953, and the Life Insurance Corporation of India under the Life Insurance Act of 1956, etc. The second one is the registered companies. Registered companies are formed and created by the Companies Act providing for the registration of the companies in India. The first act for registration of the companies in India was passed in 1850, which was subsequently amended in 1857, then in 1860, then 1882, enactment of 1913, then in 1956, then in 2002, and finally with the new and current legislation of 2013 as Companies Act of 2013. Now let's have a look upon the characteristics of the company. A company, creature of law as corporate body and clad with various rights, obligations and powers and duties. Thus, incorporation confers many advantages to the company. Following are the advantages, implications of the incorporation. First, it is separate legal existence. Incorporated company has a separate lawful or juristic existence, autonomous of its constituent individuals, and consequently the company has legal personality of its own. Then restricted liability. Liability of the natural persons in the company in case of closing stages of the company is restricted to the not paid value of the shares purchased by him. It implies that constituent individuals are not bound to pay excess of the outstanding worth of the shares purchased by him. Then important one is the perpetual succession. The demise or bankruptcy of constituent individuals does not influence corporate survival of the company, and it survives until it wind up. Then transferability of the shares. Shares or any interest in the company are changeable assets and transferable in method provided by the company's document. Then corporate finance. The share being transferable, therefore a company can raise maximum capital by public subscription through shares or debentures. Then comes detached property. The assets of the company are completely detached from the belongings of its constituent individuals. It can be assigned, mortgaged, or conveyed by the company. The next is the centralized management. The administration of the company is altogether different from the rights, and shareholders have no apprehension with the administration of the company. What are the exceptions to the principle of corporate personality? As said above, the company is having its own separate legal existence or legal personality distinguished from its constituent individuals. such personality is the creation of law, but in actuality it is an organization of persons earning benefit from the business of the company and the real owners of it. This principle of corporate entity serves its purpose only till it is used for the legitimate business purpose only. When it is misused for the corrupt reason, the individuals associated are not permitted to take cover at the back the company legal name. In such cases, the courts smash from end-to-end commercial shield and pertain to the ruling of lifting or piercing the corporate veil, that is, looking behind the corporate entity. The corporate shield is lifted in the case listed below for determining the genuine nature of the company in the times of war. Then, in case to prevent evasion of taxation by the constituent individuals of the company, then to prevent fraud or else improper behavior of the constituent individuals of the company, and to penalize the real persons in quasi against the law, and lastly to avert misuse of course of the law. Now, friends will describe about the classification of the companies. The Companies Act of 2013 provides for three fundamental types of companies registered under the Act. These are one-person company, the private companies, the public companies. These may be the companies restricted by shares, in which the accountability of the member in case of closing down is narrow to the amount of not paid worth of his shares, and the companies restricted by guarantee, wherein accountability its constituent individuals extends, undertakes or assured by them in event of winding up. An unlimited company, as the name suggests, the liability of its constituent members, individuals, is unlimited. Now, what is company of one person? A company of having only one constituent individual is called one-person company and created as a private limited company. What are private companies? Section 2, Part 68 of the Act defines private companies as a company which has minimum paid up capital of 1 lakh rupee or such higher paid up capital as may be prescribed, and by its articles normally limits the right to transfer its shares except in case of one-person company, and confines the figure of 200 provided that where two or more persons hold one or more shares in the company together are treated as single member, and further provided that the present and former employee of the company are now be counted in the number of constituent individuals, and does not allow any call to the public to give to for any securities of the company. The third type of companies are the public companies. According to Section 271 of the Companies Act 2013, a public company is a company, not a private company, having smallest amount paid up and about capital of 5 lakh rupees or such superior paid up capital as may be given. A company supplementary of the public company is presumed to be a public company. Any association consisting of not a similar amount than 7 constituent individuals registered under the Companies Act, not being a private company, is a public company. What is the procedure to change of any private company into public company and vice versa? A private company can turn into public company by amending its articles by particular resolution in a way that all the restrictions on it as a private company comes to an end. Similarly, a public company can become private company by passing a particular resolution by adopting the above said restrictions of the private company. Now we'll discuss the company formation and its promotion. The company formation involves three stages. The first is promotion, the second is incorporation and registration, and third one is commencement of the business. The first, promotion of the company, denotes the process of bringing into survival by two or more persons having an objective to shape it and take needed actions. These persons are called promoters. In section 2, part 69 of the Act, promoters are defined as the persons who has been either mentioned in the prospectus of the company or recognized in the yearly return, or having power over the dealings of the company, or gives instructions to the board consisting of directors of the company. Incorporation of the company involves getting incorporation certificate from the registrar of the companies by registering certain documents and paying certain fee and stamp duty with the registrar of the companies. Beginning of the business. Every public company owning share capital need to get certificate of commencing called trading certificate from the registrar on fulfilling the minimum subscription, whereas a private or public company not having share capital can commence business immediately after getting the incorporation certificate. Now, dear students, we'll discuss about the various documents of the company. There are certain basic documents of the company which sets out the constitution, the fundamental structure and functions of the company. They are: first, memorandum of association, then second one is the articles of association, and then third is the prospectus. Let us discuss the memorandum of association. Memorandum of association is indispensable deed of the company. It prescribes the name, registered office, object and investment of the company. It also defines the scope of the company as per section 2 of the Companies Act 2013. Memorandum means memorandum of association of company as initially shaped or changed from time to time in pursuance of any earlier law of this act. Now we will discuss about memorandum and its contents. The memorandum of a limited company must contain the following fundamental clauses. First, the clause of name specifying the name of the company, then clause of registered office, then clause of object setting out the purpose for which company is formed, then clause of liability stating accountability of the constituent individuals to be limited, and clause stating the amount of the allowed capital of the company, and lastly association clause or subscription clause in which the person subscribes their signatures to the memorandum of association. The second one, the articles of association, are the internal regulations governing the management of domestic relationship of the company. Section 250 of Companies Act 2013 defines articles of association as the articles of association as initially shaped or changed from time to time in pursuance of any prior law or of this act. Articles and its contents. The articles provides for the rules and regulations of the management of the company's internal affair. The articles generally contain the following matters. First, approval of the contracts enter in the beginning, then capital rights and their variations, then allocation of the shares, then call on shares, then right of retention of the company on shares in respect of unpaid amount, then reassign and diffusion of the shares, then forfeit of the shares, allotment of the share capital, share certificates, exchange of share into stock, choice of right to vote, right to proxies, then about the meetings, then directors, their appointment, their qualifications, remuneration, their powers, duties, and election of the chairman, etc. Secretary, his appointment and remuneration in the company, borrowing powers, dividend and funds, financial records and checks, liquidator powers in closing down the deal with assets, indemnification of the officers out of the assets of the company. Now let us discuss about the prospects. Any document showed or issued as a prospectus or any notice, circular, advertisement or other document welcoming offers from open for the payment of or procurement of any securities of a body company. Now the various contents of the prospectus are: the prospectus or to have a declaration that a replica of it has been given for the registration demonstrating vital credentials delivered therein. Prospects include the object of the company, the number and classes of shares and interest thereon, name, addresses, description and occupation of directors, least amount of contribution if shares are offered to public, then time of opening of contribution inventory and the amount to be paid on subscription and allocation, etc. Now we'll describe what is share capital. The expression capital commonly means the sum of funds to being a big business, but with reference to the company it carries different names. As in case of company limited by shares, capital means the share capital, that is the number of shares of fixed value. The different types of capital. In company law, capital is classified into kinds such as nominal or authorized capital, which is the sum declared in the memorandum of association. Then issued capital, which is perceived value of the shares issued for subscription. Then subscribed capital, the part of issued capital actually purchased by the subscribers of the shares in the company. The next is capital called part of the subscribed capital called up by the company. Then uncalled capital, the amount not yet called up. Then capital paid, the amount paid up or credited as paid up. And reserved capital, the part of uncalled capital not to called exclusive of in the happening of closing down of the company. And lastly, capital consisting of shares, the capital of shares issued by the company. What are called as shares? Section 2, Part 84 of the Companies Act 2013 defines share as a share in the share capital of a company and includes reserve except where a difference between stock and shares is articulate or implied. The different types of shares are: the share capital of a company restricted by shares may issue two types of shares. Basically, first is preference share capital and second is equity share capital. The preference shares. The preference shares are those shares which bear the preference and have superior rights with regard to two situations. One, disbursement of dividend, that is, a preferential right is owed at a fixed amount of dividend. Second, the reimbursement of the wealth in case of closing down of the company. These shares may be of following kinds: collective or non-collective, participating or non-participating, then exchangeable or unexchangeable, and then convertible or unconvertible shares. In case of collective preference shares, if there is no profit in the existing year, then the dividend of that year is to be paid in next year. That is, the dividend keeps on circulating until paid. In case of non-collective shares, the dividend is only to be paid part of the earning of every year. In case of participating preference shares are permitted to preset special payment and in accumulation a chance to take part in excess profit if any in the year. Non-participating preferences do not enjoy this right. Exchangeable shares gives option to the company to pay back the holders of such shares, whereas unexchangeable shares cannot be paid back. Then the holders of convertible shares have the right to get their preference shares changed into equity shares. The shares not having the right of change are non-convertible shares. Now, what are equity shares? If all the shares issued by the company are not preference shares, rest all are equity shares of two classes, either equity shares by way of having rights of voting or equity shares with disparity rights as to dividend, voting or otherwise in the agreement with rules as provided by the central government. Company directors. A company is a creature of law and being artificial person cannot act on its own. The human agency carrying on the dealings of the company is called directors of the company. Thus, only a natural person can be appointed as a director of the company. Section 149 of Companies Act 2013 provides that each company ought to have board consisting of directors. The number of directors should be minimum of 3 directors in case of public company, in private company 2, in person company 1 and 15 in most cases above. Selection of directors by proportional representation, that is, not as much of 2/3 of total quantity of its directors in agreement with the theory of comparative demonstration. Selection of directors by board as provided by the articles in case of appointment of additional director, alternate directors, nominee director, etc. Now we'll discuss the powers of directors. The powers of directors are set out in the articles of association of the company. These powers are either the universal powers vested in the board consisting of directors or the precise powers vested and availed by the board just at the board meeting. General powers of directors include the powers to do every act as authorized in the memorandum and articles of association of the company or as delegated by the articles. Specific powers includes powers to be exercised on behalf of the company to exercise supervision, manage and course of the functions of managing director or manager, appointment of first auditor, filling up the casual vacancy and appointment of alternate or additional directors if provided by articles. Then powers to be exercised in board meetings includes the power to make call on shareholders, power to issue debentures, borrow money, invest funds and power to make loans, etc. Then what are meetings? Meeting generally means gathering or convergence of 2 or additional people for transaction of several legitimate business. With reference to company, the term meeting connotes general meeting and class meeting. General meeting signifies any meeting of those constituent individuals having voting rights and entitled to attend. Class meetings are done to pass resolutions obligatory merely on the constituent individual of the class of shares concerned and only they can attend. General meetings may be of 2 kinds. 1. Annual general meeting and 2.
extraordinary general meeting, the periodical all-purpose gathering of every public, private company annually of its constituent individuals for the purpose of transacting its routine ordinary business is called as annual general meeting. Section 96 of the Companies Act requires that each company other than one-person company must in each year hold an annual general meeting in addition to any other meeting. Provide first AGM must be held surrounded by 15 months starting the date of its incorporation. Business transacted in annual general meeting includes ordinary business and special business. The ordinary business relate to the consideration of accounts, balance sheet, reports of the board consisting of directors, declaration of dividend, appointment or reappointment of directors, auditors, etc. All meeting other than the above said broad gathering is extraordinary general meeting and initiated by either directors voluntarily or on the requisition of constituent individuals to discuss some special or urgent business. Now, what is the procedure to closing down of a company? The closing down is ending of the company's existence. The Companies Act prescribed two modes of closing down of a company, namely by the tribunal and closing down voluntary.
Now we'll discuss the procedure of closing down by tribunal. The enforced closing down of a company by tribunal is done by any submission by means of formal request to the tribunal in the following circumstances. First, inability to pay debts by the company. Then, special resolution for closing down passed by the company. Company acted national interest, where company becomes sick company. Closing down on application made by the registrar notifying that company has been formed for unlawful purpose and on default of the company in filing with the registrar its financial statement. Closing down on any just and equitable ground such as deadlock in the management of the company, company losing its substratum, mismanagement and losses in the company, oppression of minority shareholders by the majority, fraudulent or illegal purpose, and when private company is in essence a partnership firm and there is abuse of power or breach of good faith. Then closing down voluntary. Company may be willingly closed by the constituent individuals of the company in one of the following manners. First, by ordinary resolution. Then other is by special resolution.
The various modes of voluntary winding up. It involves filing up the declaration of solvency by the directors to the effect that they have made complete survey into the dealings of the company and it will be able to reimburse full amount outstanding from the earnings of the property sold in deliberate winding up. Appointment of company liquidator for performing the functions and discharge of duties regarding settlement of list of contributories, maintaining proper accounts and paying the debts of the company and calling the company's general meeting for laying down the progress report of winding up. After the company's affairs are fully wound up, the liquidator call the final meeting and lays down the full report of winding up. The replica of the accounts and the minutes of the meeting are sent to the registrar to that effect.
So, the students, let us now summarize what we have learned in this module. The Companies Act of 2013 covers law of companies in India. The Act provides a framework of the companies, its kinds and important stages from promotion of the company till its incorporation and binding up. The principle of corporate personality is the gist of incorporation in India. The important documents like Memorandum of Association, Articles of Association provides the constitutional structure of the companies. Concepts like share capital, directors and meetings helps in understanding the functioning of the corporate business in India. Ideally, the Companies Act of 2013 is a complete legislation dealing with company law in India. Thank you.